Landlords and property managers, if you have a business entity and you use that on your 3-day notice, make sure it's your legal name as published by the California Secretary of State. Hi, my name is Rob Wells. I'm the Landlord Warrior on TikTok and YouTube. Please feel free to like, share, and subscribe to our videos. Now, I just reviewed a case. It was a case for non-payment of rent. The landlord is a business entity. I think it's a corporation. So what they did was, on their 3-day notice, they listed where to make the payments deliverable to. They made it to their corporation, their address, telephone number. That was great. However, this property management, whoever prepared the notice, did not use the full legal name as written down by the Secretary of State's website. That's a problem. There was just a recent case. The city of Alameda actually got called out by the Court of Appeals for that same issue, stated that the notice was defective. Let me back up for a minute. So you've probably heard us on the channel talk about what's required on a 3-day notice to pay rent. The law is very clear. You got to tell the tenant or demand that payment be made to a designated person, an address, a telephone number, and if you can drop off rent in person, the usual dates and hours that that person or entity will be available. Now, this Court of Appeals decision, it's called City of Alameda versus Sheehan. I'm probably mispronouncing that. That's reported at 105 Cal App, the 5th edition, page 668, basically. Okay. Before, in the old days, when I started out, they changed the the non-payment of rent statute a couple of times, and I think it had always been the case that we would have to designate a natural person. There are a lot of courts that would say, hey, the statute reads person, that means natural person. Well, this case actually clears that up. The court actually pointed out there's a provision in the Code of Civil Procedure, basically, that deems a corporation or LLC, a registered business entity, as a person for purposes of the non-payment of rent statute. So, long story short, without getting into the legalese and all the arguments and stuff, the court said, hey, it's okay that a business entity lists themselves as where rent can be delivered for purposes of the non-payment of rent statute. However, your name, legal name, has to be exactly as it's published by the Secretary of State. Commas, if you put INC for incorporated, you have to use that, okay? Because the city of Alameda got called out on that case for that very reason. Whoever prepared the notice basically didn't put down the property management company's name as published by the Secretary of State. The court said that's a fatal defect. You have to name your entity as what the legal name is called. So, for example, my office name is Law Office of Robert M. Wells, a professional law corporation, written out. Okay, it's not APLC. If I were to do a 3-day notice, I'm a property management company, I would have to state all that stuff out there. So, a little bit of good news for our business entities. I always would tell people designate one natural person, but now with this case, it came out recently, like last September 2024 here. You can use your business name, but it needs to be published by this, use exactly what you have on the Secretary of State's website. Landlords, property managers, if you're going through a non-payment or rent situation or any type of landlord termination tenancy matter and you're in the Northern California area, please feel free to reach out. We might be able to help out. If you got comments, questions, put them down below. Until next time, folks, I'll talk to you then. Thanks.